HIWU, the Horse Racing Integrity and Welfare Unit, was established in 2022 by Drug Free Sport International to run the Horse Racing Integrity and Safety Authority's, or HISA's, anti-doping program. Previously, every state managed their own testing programs differently. Now, HIWU manages a nationwide uniform testing program at all HISA racetracks by using a comprehensive testing plan, overseeing all of the test barns, managing the labs, sending notices of violations, and prosecuting those violations. This video reviews the process for when a horse tests positive for a prohibited substance. The most common violation of HISA's Anti-Doping and Medication Control Program, or the ADMC program, is a presence violation, otherwise known as a positive test. After a lab sends HIWU a report for a positive test, HIWU reviews the relevant documentation to ensure the applicable rules and procedures were followed before notifying the trainer of the potential violation. The next step is that HIWU serves the notice of violation on the trainer. For controlled medication violations, the trainer and owner will be sent the notice at the email address he or she entered in the HISA portal. If the trainer or owner does not have an email address listed in the portal, the notice will be sent to them by regular mail. For more serious doping violations involving banned substances, the notice will usually be served in person by HIWU investigators. Covered persons should ensure that all of their contact information is correct in the HISA portal so that they receive notices and other communications from HISA and HIWU. A notice of a violation tells the trainer the details of their potential ADMC program violation, the next steps in the process, including what rights they have, and the sanctions they may be facing. It also lists the phone number and email address for the lawyer that HIWU has assigned to the case. The lawyer will serve as the point of contact between the trainer and owner and HIWU. If a trainer has questions about the notice or would like guidance related to their case, they can contact HIWU's ombudsman. The notice includes instructions on requesting a B-sample analysis. Trainers have 5 calendar days from the date of the notice to request B-sample analysis by sending an email to banalysis@hiwu.org. Within 7 calendar days of that request, the trainer must pay for the B-sample analysis through the HISA portal before the sample will be shipped to the B-sample lab. HIWU will select one of its partner laboratories to test the B-sample. If the trainer cannot afford to pay for the B-sample, they can apply for financial assistance. If the trainer doesn't request the B-sample analysis and make their payment in time, the B-sample analysis will be considered waived. Trainers can also decide not to go ahead with the B-sample analysis. To do so, trainers can sign and return an acceptance of A-sample results and B-sample waiver form. This form is included with the notice and should be returned to banalysis@hiwu.org by the listed date. Before HIWU issues a formal charge, trainers have the opportunity to provide an explanation to HIWU regarding the positive test. The explanation should address the source of the prohibited substance that caused the positive test, why the trainer believes the positive test was not their fault, or why they had minimal fault for the positive test. If trainers want to send documentation or other materials to support their explanation, they can send them to the lawyer assigned to their case. Trainers can also try to resolve their case without a hearing by reaching out to the lawyer assigned to their case. In some situations, a provisional suspension may be imposed on a trainer and/or the horse. If a suspension is imposed, the details will be explained in the letter, so trainers should read it carefully. In most cases, the trainer will not be provisionally suspended until the B-sample confirms the A-sample or the trainer elects to not have the B-sample tested. If a trainer is provisionally suspended, their horses cannot breeze or participate in any race in HISA states. However, the trainer can still care for and oversee the exercise of their horses. In addition, they 1. Must take down or cover any personal signage in their barns or wherever their horses are located on the racetrack. 2. Cannot claim horses or bring new horses into their barn in HISA states. And 3. Cannot be employed in any capacity involving covered horses. This includes acting as an agent for an owner of covered horses or working as an exercise rider for covered horses. For provisionally suspended trainers, All of the covered horses in their barn may not breeze or participate in any race in HISA states, unless the covered horse or horses have been transferred to another trainer. Transfers must be reflected in the HISA portal and can be completed by calling HISA's support line 1-877-513-2919. Provisionally suspended horses may not breeze or participate in any races in HISA states. Provisionally suspended trainers have the right to request a provisional hearing for themselves and any provisionally suspended covered horse. A request for a provisional hearing must be made in writing to the HIWU lawyer assigned to the case. Provisional hearings are conducted by the provisional hearing arbitrator by telephone or video call. Trainers have the right to be represented by a lawyer at all times. If they cannot afford an attorney and are facing an anti-doping rule violation, they may apply for pro bono counsel via HISA's Legal Assistance Program, which provides free lawyers to trainers who cannot afford to hire their own lawyers. Information about the program is included in the notice provided by HIWU. The information in this video has been simplified to make it easier to understand. For more detailed information, please consult the ADMC program regulations submitted by HISA to the Federal Trade Commission, which were published by the FTC in the Federal Register on January 26th of 2023.